this morning's docket. Case number 113191 in the matter of James Andrew Klein.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. Mr. Chief Justice, again, I'd like to reserve 2 minutes.
2 minutes is granted.
Hearing in this disciplinary case occurred on the same date, September 17th of 2014, as they were consolidated. Respondent appeared in person at that hearing with counsel Steve Kavanaugh. The case was submitted to the panel by stipulation, and the respondent admitted violating KRPC 1.4 communication and KRPC 8.4D, conduct prejudicial to the administration of justice, for misleading the complainant, his client, in the disciplinary case. And in this case, the complainant was the client, in misleading her regarding the setting of a hearing in her case. And also actually on 2 different occasions, and the panel noted that he attempted to conceal his misconduct by telling the client that she didn't need to appear at the hearing. There were no exceptions taken in this case to either the findings of fact or conclusions of law. Both the panel and the Disciplinary Administrator's Office recommended indefinite suspension in this case. My understanding is that the respondent is not presently practicing law, and at the hearing, he requested that his suspension be for a period of 2 years. In support of my recommendation, I'd like to argue to the Court as follows. And these are some findings made by the panel, plus my own observations and argument. The respondent's conduct was engaged in knowingly. The panel made that finding a fact, and there has been no exception to that, including an attempt to conceal his conduct. His misconduct was motivated by dishonesty and selfishness. There was a pattern of misconduct because he provided false information on 2 different occasions to his client and 2 different phone calls regarding the setting of that hearing. They found that the vulnerability of the victim was also an aggravating factor, and they found that the prior discipline was an aggravating factor. Now, in the other case, the prior discipline occurred 24 years ago. In this case, the prior discipline occurred, and the respondent was actually suspended on October 9th by this court of 2009. He was suspended for a period of 3 years. He was given the opportunity to file for reinstatement or request reinstatement after a year, which he did. And he was reinstated on June 22nd of 2011. And he was placed on probation for the remainder of his suspension. In the 2009 case, the respondent's misconduct affected multiple clients. There were 4 complainants in that particular case. There were a number of instances of misleading clients, as occurred in this particular case. There were missed statute of limitations. There were findings of lack of competence. And there were findings of resulting actual harm to those clients. The panel in this present case noted that the misconduct in this case was, and I quote here, substantially similar to the misconduct in the 2009 case. And certainly that 2009 case, you cannot argue that it would be remote in time. Under these circumstances, I feel indefinite suspension is warranted. The respondent, I'm sure, will tell you when he gets up here that he has fought depression throughout his legal career, and I believe is still under treatment for that. His misconduct has affected a number of clients adversely. The first, resulting in the first serious discipline case, and now we have the second serious discipline case. The indefinite suspension will protect the public and require the respondent to go through a reinstatement process at the end of the 3-year period of time, if he decides he wants to practice law. Now, there was some testimony in this disciplinary case that he really has no intention of doing that again, or if he practiced law, it was my understanding that he didn't feel like private practice was his niche. In my estimation, it would be absolutely necessary for the respondent to prove to a panel and to this court by clear and convincing evidence that he's fit to practice law again after these 2 serious disciplinary cases. Be happy to answer any questions.
What would that look like? What would proof that he can practice law without endangering the public? What would that proof look like?
I think it would have to be pretty compelling evidence, Your Honor. Through the testimony of professionals, whether they be psychiatrists or medical doctors, that in their opinion he would be able to practice. Pretty compelling evidence that he'd been undergoing treatment for 3 years when he applied for reinstatement. I think that would be the main thing that would have to be proved, because there's no question in my mind that there's a correlation between the depression and what happened in both of these cases. Not an excuse, but it's there.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Stephen W. Cavanaugh. Mr. Klein takes no issue with the facts in this case. He stipulated to the facts. It was submitted to the hearing on stipulation. He also stipulated to the violations of KRPC 1.4 in failing to advise the client that statute of limitation had run on her case. And as you heard from Mr. Hazlett's comments, the statute actually ran in July of 2010. Mr. Klein at that time was under suspension, had no client contact, and it wasn't until June of 2011 that he was reinstated. When he was reinstated in 2011, he commenced then assisting on that case with that client, now as a lawyer again. And it was at that point in time then that he had an obligation, knowing that the client had not been informed, to make sure that the client was informed. Between July of 2010 and June of 2011, he had no authority and no client contact. But once he was reinstated and he knew that the client had not been informed, he had an obligation to tell her. He also stipulated the violation of KRPC 8.4D, and this was lying to a client that he had filed a motion for penalties and attorney's fees in a workers' comp case, and that the matter had been set for hearing. He had an opportunity in a later phone call to correct that. He did not. He told the client she didn't have to appear, and that was a situation that he had nothing to gain by that, nothing to gain by the avoidance of talking to the client and telling her what really had happened. I mean, there was no logical gain for him, and he had everything to lose when you're dishonest with a client. Mr. Klein acknowledges these are very serious violations and warrant suspension. The hearing panel, as Mr. Hazlett set forth, found aggravating circumstances, and probably the most serious of which is the fact that in 2009 he had a 3-year suspension with similar conduct, and as occurred here, and then this led to a further finding of aggravating circumstance that there was a pattern of misconduct. Looking at the aggravating factors here, look at these facts. The question is, why is disbarment not appropriate? What's different in this case? I think to answer those questions, we have to look back at what happened in 2009 with the 3-year suspension. Mr. Klein, with the complaint in 2009, he continued to practice all the way up to the point in time when the suspension took effect, and then he ceased. During the suspension, he continued in the legal field as a paralegal. There was no separating himself. He had a 3-year suspension, but he had the opportunity to, after 1 year, to file a petition with this court to be readmitted, which he did. In hindsight, it's clearly too soon. And he also at this time discontinued therapy with the counselor that he had been undergoing during the suspension, believing that he could handle what was happening to him from a depressive standpoint. But what didn't happen in 2009 is he didn't take the time to learn and understand how depression was affecting him and how he could manage that depression so he could be a functioning individual and a functioning lawyer. He was first diagnosed officially in 1999 with depression. Renee Cristiano, who provided expert testimony at the hearing, testified that in her opinion, she believed that the onset was probably as early as his freshman year of college. He was never treated for depression until 2008. That was the first time he underwent any treatment. In mitigation, the panel acknowledged that Mr. Klein suffered from depression for many years and was suffering from depression at the time of the misconduct. And the panel found that it is clear that the respondent's depression contributed to his misconduct. Now, the difference is now from 2009 that Mr. Klein, a year ago, in early May of 2014, voluntarily suspended himself from the practice of law. He has not engaged in the practice of law, representing any clients, working for a law firm since early May of 2014. He recognized that he was not in a position, due to his illness, to be able to provide the standard of care to the client that the clients would deserve. He recognized that he needed to take serious steps to get his depression treated. And he engaged with Renee Cristiano, a licensed social worker, board certified, in counseling, and has continued that counseling and is currently still doing so at the present time with Ms. Cristiano. He recognized that he had to learn to engage in self-care, to be able to take care of himself. He also recognized that this was something that he couldn't handle just by himself. And he engaged as an active member of an impaired lawyers group in Wichita, which deals with depressive lawyers. He is active in that group, has been active for the last year, and continues to do so. At the hearing, Ms. Cristiano testified that James Klein's depression caused impaired decision-making. He was making decisions that, in the perspective of non-depressed individuals, would seem reckless and irresponsible. Exactly what occurred in this case, particularly with the dishonesty with the client. It also created an avoidance. He just wasn't able to face this client without any concern for the consequences. That decision, he had to have known but could not appreciate the negative impact it would have on his career, his law license. His depression impaired his ability to make rational, logical decisions, and in life as well as in the practice of law. He was immobilized from rationally doing what was required under the circumstances. Ms. Cristiano testified at the hearing, although that the counseling at that point in time had only been 4 or 5 months, that she was very pleased with the progress, that as a patient he was extremely cooperative, that he actively engaged, that he followed through with recommendations that she made, followed through with homework that he gave, and that she was very, very pleased with him. James continues in counseling today, and the results have been good. He's gained a better understanding of depression and how it affects him. He's learned how to recognize triggers and symptoms, which is one of the goals that Ms. Cristiano testified that she was working with him for. And it's an invisible illness. And if you don't realize when you're entering a period where it's really starting to drag you down, if you get too far underwater, you can't reach above water and seek help. And so they've worked very hard, and he feels that he has a much better understanding of realizing that maybe he's starting to feel the impact of the depression becoming more severe. And in time that then now he can seek out and obtain help to make sure that it does not impact his good decision making. Ms. Cristiano also gave an opinion at the hearing that she did not believe that Mr. Klein was a deceitful person. but it's this impaired decision-making and this avoidance that led to the dishonest conduct in this case. More importantly, it was her opinion that with proper therapy and continued assistance that he could get to a point where he would be able to manage his depression to a level that he could return and be an effective lawyer and practice law again. Mr. Klein is not ready to return to practice law. He understands that. He understands also that he believes it would be a mistake to, when he did have the opportunity to return to practice law, to engage in the plaintiff's personal injury type work he had done. He has recognized that he is going to be better off in more of a structured environment. And when he has the opportunity, which I hope he will, to utilize his law degree and to act as a lawyer, it's his goal now to seek out a position that would provide some kind of structure there. The personal struggle with depression of Mr. Klein has cost him 2 marriages and a law practice. But he has taken positive steps to salvage his career and his life. And he's demonstrated through his affirmative actions over the past year and his cooperation with this process that he deserves the opportunity to practice again. We do not take issue with the hearing report, but we would request that any suspension could begin retroactively to the date that he voluntarily suspended himself from practice. If there's any questions, I'll be happy to address those.
Go ahead.
I have a couple questions. At what point in time did Mr. Klein tell his supervisor, Mr. Ehrlich, that there was a problem in this case?
With the statute money? Well, my understanding is that Mr. Ehrlich was aware of that because Mr. Klein did not have any responsibility for obtaining service. I think Mr. Klein may have had some communication with an insurance adjuster during the period of time, and where the insurance adjuster was indicating that because it was only a $25,000 policy limit on the driver, and so it was a case that there would probably be an expectation that the insurance company would end up paying policy limits, tendering those, and so my understanding that he may have had some communication there, but that at the time that the statute ran, that Mr. Ehrlich was aware of that at the same time.
Okay. And lastly, when he was suspended, indefinitely suspended before and then reinstated, I thought I heard you say that he was reinstated with a probationary term?
No, Your Honor. Okay. That if I indicated that was I misspoke.
So he was just straight reinstated, no other supervision needed at that point?
That is correct.
Okay, thank you.
And at this time, if there's no other questions, I would like, Mr. Klein would like to address the board.
I did have a question for you, counsel.
Yes, sir.
I'm looking at the findings of the panel, basically findings 22 through 24, which have to do with the workers' compensation hearing. And there are a couple of matters that are not reflected factually in here, so I'm going to ask you. It talks about the state office building, 7th floor. Is that in Topeka?
I believe that is correct, Your Honor. I'm not sure I can answer that decisively, but Mr. Klein would be able to.
And my second question is, this action was filed in Butler County, but where did the client reside?
I believe the client resided in the Wichita area, and this was a combination of workers' compensation auto case because she was traveling for her employment.
I understand that. What I'm interested in is the finding that says, this is finding 23, on August 15, 2013, or August 16, 2013, the client again spoke by telephone with the respondent. During the telephone conversation, the respondent told the client that the hearing was scheduled for 9 a.m. in the state office building, 7th floor, which you believe is Topeka. The respondent told her she did not need to be present during the hearing. And then finding number 24, on August 22nd, the client and her husband went to the workers' compensation office at the state office building, 7th floor, which you believe is in Topeka. So my question is, it sounds like he told her, here is the hearing date, but you need not go. And then she and her husband drove from the Wichita area to Topeka for the hearing, which had not been scheduled for her. Is that a fair statement?
Well, Your Honor, I cannot specifically say whether we're talking about State Office Building, Wichita, or Topeka. Being a resident of Topeka, when I hear State Office Building, I obviously immediately think of the building here in Topeka. But it is true that he told her she did not have to appear because there had not been a hearing set. And the client chose, she and her husband went to hearing voluntarily to appear, and that's when they learned that the hearing had not been scheduled. And then from there, they did go directly to the Render Camus offices.
And in finding 22, it said that she had sent him a letter by certified delivery asking whether she was required to be present during the hearing and informed the respondent that she wished to be present during the hearing. And then she followed up by phone, as I indicated earlier, and he said, you don't need to appear. In light of these facts, I'm asking whether, in your view, this is explainable by the diagnosis of depression, or is it something else?
Well, I think the depression, where the depression entered into it, this workers' compensation case, from the date it was filed, extended to a lengthy period of time, more than I think you would see in an average workers' compensation case. With the investigation done in this case, that was looked into, and as to whether or not this delay or the time frame of this case running was based upon misconduct of Mr. Klein. And the investigator did not find that was the case. There was a substantial delay in getting the judgment, and I'm not a work comp lawyer, Your Honor. There was about a 6 months or more delay in getting the award. And so this was a case that had been dragging on for a long time, not Mr. Klein's fault. I think at this point in time, with the depression setting in on the client, and it was also a case that once the award was rendered, it was not appealed, but the insurance company was not paying it. And so therefore, that was the need to file an earlier demand for payment, and then when it still wasn't paid, to file the motion for penalties. And so during this period of time, the client obviously wanted her money, and she was calling on a regular basis. And I think this got to a point, Your Honor, where he just couldn't face her anymore, and that was the explanation provided by Ms. Cristiano in her testimony.
So when she calls and says, what's the status? And he says, oh, this is set for hearing. And then she later contacts him and says, do I need to be present for the hearing? And he says no. And then she and her husband drive to the hearing anyway. What you're telling us is that is all explainable because of his depression. Is that a fair statement? Is that fair?
It was, again, the avoidance, Your Honor, but I think, I had referred to that in my earlier argument that he had the opportunity to correct the misrepresentation he had already made with that phone call, and he failed to do so then.
He actually kind of compounded it.
Yes, he did. There's no question. No question. He compounded the situation.
And just so I'm clear, are you saying that his witness testified that is a manifestation of avoidance, and the avoidance is a manifestation of his depression?
Well, I'm not sure the testimony went to that specific phone call, but the act of telling the client that the motion had been filed and that the hearing was set was a manifestation of the avoidance which was brought on by that impaired decision making.
All right, that's what I was looking for. Thank you.
Thank you.
Any more questions of counsel? And your client
May
would
Mr.
like to
Klein
speak?
address the court, Your Honor?
Yes.
May it please the court. First, would like to apologize for you being here. I'm sure this is not a very pleasant part of your job duties. I would like to answer a few questions that the court came with. First, the hearing was in Wichita, Kansas, the 7th floor of what was in the state office building. The workers' compensation court has moved several times, so that would have been on the 7th floor of that building in Wichita. When I advised, I don't want to go into a brief factual background. The case had already gone to hearing in August of the prior year. We had submitted all of our evidence by that time. The administrative law judge, by statute, is supposed to submit an award within 30 days. That didn't happen. The administrative law judge on several occasions indicated she would get the award out, and I told Ms. Daniel Droney that the award would be issued. The award was finally issued in May of the following year. It was not appealed by the respondent. So at that time, her judgment was set. She already had her award in the workers' compensation appeal case. The respondent's attorney did not appeal that, but they also likewise did not pay the award that was already issued by the administrative law judge. There was no appeal, but they just did not pay it. So that necessitated the demand for penalties. Through the hearing that we come to, which I misrepresented Ms. Droney, this is a hearing for penalties. These are set twice a week in Wichita, in the workers' compensation case. This is something, when I told her it would be on August 22nd, I told my assistant to schedule the penalty hearing the first possible date. That was the first date given by the court that was available. I told Ms. Droney we would have a hearing on the 22nd. As it happens, the respondent's attorney had not gotten back with my legal assistant, and so the hearing was not scheduled. And I could not tell Ms. Droney that it had been canceled. At that point in time, this case had been dragging on for 5 years. She would still receive medical treatment. It had become somewhat of an adverse relationship. Ms. Droney had contacted me several times regarding whether the award would be issued, why wasn't it paid, and my depression got to the point I just could not have her yell at me one more time, and that is the reason. I understand it sounds completely irrational, and it was. It was a product of an impaired mind. My depression was so severe, I could not face her and tell her, no, that hearing has not been set. In all reality, the hearing for penalties could be set the next week, or you just have to give 7 days notice in workers' compensation court. Had I not been acting with a mental impairment, I would have just said, I'm sorry, the other attorney didn't get back with us, we're going to have to continue for 2 weeks. That's all it would have taken. But at that point in time, I was completely frozen. I could not handle her yelling at me one more time. And that's the reason I avoided it. Since that time, and since her complaint, and I apologize to her, within 30 minutes of her realizing that the hearing was not set, I have handed all my cases off to other competent attorneys. I realized that I was not competent at the time, under my mental impairment, to represent clients to the best of my, well, I could represent to the best of my ability, but my ability was impaired, and that was not in their best interest to have me represent them. I have not practiced law since May of last year. In fact, it began in April, handing the cases off to other people. Since that time, I've continued to seek counseling with Renee Cristiano, a licensed social worker, who's a fantastic person, a miracle worker in my case, in my understanding. I have given her a card to many other people. I meet monthly with a group of attorneys in Wichita, Kansas, led by David Hebert, and he gave me permission to use his name. It is anonymous. Dave, this group of attorneys is fantastic, and I would highly recommend them to anybody who reads the decision or who is watching here today, that there is a group who's willing to help you, that you can get out there and understand that depression is going to be there. I continue to take my medications, I continue in therapy, I meet with these people, but the difference between the last time I was unfortunately before this court and today is that with Ms. Cristiano, I have she used the term self-care, and that's something different than I had ever done before. I have focused on learning the triggers, my response to the triggers for my depression, ways to cope with it, how to notice what is going on. First time I met with Renee, she gave me deliberately gave me a pad of Post-it notes and said, write down every time you have a negative thought and why. In the first couple of days, I almost went through her stack of notepads. But now I understand those. I have focused on the self-care and understand the triggers that are going on, and understand how depression affects me. And I cannot say that it affects everyone the same way. I can tell you it affects many people in the same way. I worked with the group in Wichita. I will continue to work with the group in Wichita. I would like the opportunity sometime in the future, and yes, I believe fully that I should come before a panel with testimony from Ms. Christiana or whomever and present evidence that if I were to be able to practice law again, that I will continue in treatment, I will continue to take my medications, I will continue to meet with the group in Wichita. That is the only way I would continue to practice law, because I understand now the extent to which this mental illness affects me, and I did not fully understand that the first time I was before this court. And that is the difference today. I would just ask the court, if you so find, that I would be given the opportunity to continue to work with attorneys, in the Wichita area and throughout the state, to let them understand that there is light at the end of the tunnel, that from someone who at one point in time believed when I had 4 children that it would be best for me to drive them to a bridge because that would be best for them to get a workers' compensation claim and life insurance proceeds, that you can overcome this, you can deal with it, and you can eventually become a productive member of society and a member of the bar. The day after we leave, I'll go home, have the opportunity to pick up my 2 young children, and they'll come run into my arms, and they'll tell me that they love me, and I will, for the first time in a long time, believe that I am worthy of that love. And I think I would ask that I have the permission to work with other attorneys to show that there is light at the end of the tunnel. Thank you.
I'm curious, this is almost a combined case, you and Mr. Ehrlich,
Yes, that's correct.
and I'm just curious whether you two have had conversations about this situation and how you got into this spot. In other words, he was your supervisor, correct?
Correct. Do you mean how we got to this spot? I have not had any conversations with him since our disciplinary hearing. At the time we practiced, at the time the incident occurred, when the service was not obtained, we had discussions, and it was the adjuster on that insurance claim. I could not file the lawsuit. At that time I had been suspended. Mr. Ehrlich filed the lawsuit. I believe I prepared it. He signed it. I had notified the adjuster that I had been suspended. I did provide information to her. As an adjuster I dealt with for many years in my private practice and personal injury. Her name was Saya Gregg. I had settled literally dozens of cases with her. It was one of those where I had a relationship with an adjuster that said, listen, I understand this is a policy limits case. I'm going to pay you the check. I just got to document my file. So it had not been a priority for me. I took her at her word. And then,
When we allowed you to come back and practice law a few
Yes.
years ago,
Yes.
I think you, or maybe your counsel, responded to a question from Judge Arnoldberger, and that is you are allowed to come back without any supervision. Is that right?
that was correct.
Okay.
And there wasn't even a hearing for me to be reinstated.
And then sometime after that, Mr. Ehrlich became your supervisor in the law firm, or at least for some of these matters. Is that correct?
For the personal injury side, Larry and I worked together. He did not
Yes.
really necessarily supervise me on the workers' compensation side.
But on the PI end, he did.
Yes.
Okay. My question, therefore, is when you were asking us for the sanction to be imposed, do you foresee a need for any kind of supervision in the future?
I would, specifically, yes, for my depression. I would agree
I mean,
that
from a
wholeheartedly.
lawyer.
I would have absolutely no objection to that. For a period of time, I think that would be prudent for this court to have someone to look at. Obviously, the first time I reintegrated into the practice of law, suffering from depression, did not turn out the way we'd all hoped. So I have no problem with somebody supervising it. So I can prove to them and work with them to show how I've come to understand the effects of depression, how it affects me, and how I have developed coping mechanisms. So I would have absolutely no objection to that.
All right, thank you. Any further questions? Thank you both
Thank you
for
for
your
your time.
remarks.
Thank you.
You've reserved 2 minutes for rebuttal.
Thank you. Your Honor, it was me.
Okay.
You said he was placed on probation. It wasn't Mr. Kavanaugh, and I looked at the order of reinstatement and saw that what was told you was correct. He was not on supervision at all. He was, once he proved he paid his attorney registration fees and his CLE, he was good to go. Again, the panel in this case found that the conduct was knowingly took place, and I want to read to you what the respondent said at the hearing when asked why he just didn't come clean about the hearing. He said, you know, quite honestly, I suffered from depression. I had in the past, very similar to what he's saying here to you today. I mean, I wasn't functioning as well as I should have. I literally could not handle her yelling at me again about that, which again is what he's telling you here today. I just avoided it, so I just told her the hearing was set. And I can't get into the mind of the panel members, but I think it must be that quote that led to them to the conclusion that his acts were knowingly taking place. I mean, he said, she's yelling at me. I can't stand to have this happen anymore. Obviously, he knew what was going on, and I don't know that there's a correlation between what he did lying and the impairment under these circumstances. You know, the practice of law, as everybody in this room knows, is a very difficult thing to do, and you have difficult clients at times, and you just have to deal with that. And he, in the past, in his first disciplinary case, I mean, if you read the facts of that case, very similar conduct, very similar reaction to being placed under stress in situations with these clients, and his reaction is to mislead them. It was in the past, and it was in this case. With respect to what the appropriate discipline is, again, I recommended indefinite suspension. And I took into consideration the mitigating factor of depression because I do believe it exists. And in my estimation, it took it down from disbarment to indefinite suspension. But I would urge the court to go no lower than that. I don't think the suspension should be retroactive. I think it should be from the date of the opinion. And I think the misconduct and the past misconduct justify that sanction by the court.
Any further presentation?
No, sir.
Any more questions? Thank you, counsel. We thank all of you for your arguments this morning. Court will take this matter under advisement.